Today, we're diving deep into estate planning, specifically focusing on probate and the legal process of retitling assets after someone passes away. This topic frequently appears on the CFP exam, and understanding its nuances is crucial for success. Let's break down probate first. Probate is the legal process through which a deceased person's assets are distributed and their affairs are settled under court supervision. Think of it as the court's way of ensuring everything is handled properly and fairly. The probate process typically begins with filing the deceased person's will with the local probate court. The court then appoints an executor or personal representative, usually named in the will, to manage the estate. Many candidates mistakenly believe that having a will avoids probate. This is incorrect. A will actually guides the probate process rather than avoiding it. During probate, several key steps occur. The executor must locate and inventory all assets, pay outstanding debts and taxes, and ultimately distribute the remaining assets to beneficiaries. The process also involves retitling assets from the deceased person's name to the rightful heirs or beneficiaries. One major advantage of probate is that it provides clear title to inherited assets. When someone inherits property through probate, they receive a court-approved title that's difficult to challenge later. This can be particularly important for real estate transactions. Another benefit is the structured timeline for creditors to make claims against the estate, typically ranging from 4 to 6 months, depending on the state. However, probate comes with significant disadvantages that clients often want to avoid. The process can be expensive, with attorney fees, court costs, and executor fees potentially consuming 3 to 7% of the estate's value. A common exam trap involves calculating these costs, so remember to consider both the percentage and flat fees involved. Privacy is another major concern. Probate proceedings are public record, meaning anyone can access information about the deceased person's assets, debts, and beneficiaries. For example, if a celebrity worth $10 million goes through probate, their entire asset list and who inherits what becomes public knowledge. The time factor is also crucial. Probate typically takes 6 months to 2 years to complete, during which time beneficiaries may have limited access to inherited assets. Many exam questions focus on this timing aspect, particularly regarding when beneficiaries can expect to receive their inheritance. A critical concept that often trips up exam takers is understanding which assets actually go through probate. Assets with designated beneficiaries, like life insurance policies, retirement accounts, and transfer on death accounts, bypass probate entirely. Joint tenancy properties and assets in living trusts also avoid probate. However, assets solely in the deceased person's name with no beneficiary designation must go through probate. To test your understanding, consider this scenario. A client has a $500,000 house in their name alone, a $200,000 IRA with their daughter as beneficiary, and a $100,000 joint bank account with their spouse. Only the house would go through probate, while the IRA and joint account would pass directly to the designated recipients. Remember, while probate provides important legal protections and clear title transfers, its public nature, cost, and time requirements often make it desirable to minimize probate assets through proper estate planning. Understanding these trade-offs is essential for both the CFP exam and your future client conversations.